could just register our presence on the chat so we know who is exactly in the meeting. That will be helpful for us. Thank you. Claire Musonda. I'm privileged today to moderate the session. I'm Director Corporate Governance at the SADC Parliamentary Forum. From the outset, I'd like to request my colleague, Mr. Modise, our media liaison, to give us a brief on the housekeeping issues, the etiquette relating to meetings of such a nature, virtual meetings, and also the media coverage that we have today. Mr. Modise, please.
Thank you very much, Ms. Musonda. Good morning, everyone. My name is Modise Kabedi, as Ms. Musonda has indicated. Please note that the session today is being broadcast live on Parliament TV, which is found on DSTV channel 408. We are also going live on the various social media platforms of the forum and also of the Parliament of South Africa. There are also journalists who have been invited to cover the session. So please bear that in mind. We request also everyone is going to take the platform to please switch on their video cameras, and also for the purposes of framing and your appearance on the screen, we request that you do the picture on a shoulder length, as I've framed myself there. Because it is very important for television purposes. Because when we have your picture on the screen, we also use your name as a indication of who is talking at that particular time. So please, it is very important. The names are usually put on this platform. So if you're going to have your face closer to this level of the screen, it means that your name is going to be where your face is. So we request that you include your shoulder when you do your picture, and include some kind of a space around you so that we can be able to broadcast the session properly. I'm also going to request that all the people that are on the platform to please switch on their videos. We request that in order to take a picture of the participants on of the session, we are going to use the pictures on our various publications. Some of them will be tweeted, and others are going to be used on the newsletter that we're going to produce for the gender-based violence model law. So please assist us in ensuring that you give us proper pictures, and also for your own, you want to be seen properly when we circulate the newsletter, and also when people view this broadcast later on Twitter and the various other platforms. So please, we request your assistance in making sure that happens. For the purposes of this session, we have been told that there's no interpretation required, so there's not going to be any need to show directly to that. Thank you very much, Ms. Nsonda. That's it for me from my side.
Thank you very much, Mr. Modise. And colleagues, without wasting too much time, let me just give a very brief background to the meeting that we're having today. The SADC Parliamentary Forum is, as you may be aware, a regional body. It's a parliamentary or legislative body that is seized with various matters of interest within the SADC region. And one of its mandates is development of prototypes for parliamentarians to assist them in executing their mandated roles. And one of the methods that the forum uses is the development of model laws. Regional model legislation acts as a benchmark to offer the highest standards or norms that national legislators should strive to emulate or duplicate, and can be used in various jurisdictions that face similar problems. So in that regard, the SADC Parliamentary Forum has developed various model laws and is still in the process of developing others. Currently, the forum is developing the model law on gender-based violence to provide a standard or a benchmark for the legislatures of the region. So in the process of developing this model law, the forum has seen it fit, as with other model laws, to undertake wide consultations with various stakeholders and partners. In the process, there's been consultations undertaken with judges in the region or judicial officers. There have been consultations with lawyers, with civil society organizations, with the youth of the region. There's also been consultations with parliamentary committees in the various SADC legislatures. These committees were specifically selected because they are responsible for gender, children's rights, police, and justice matters as well. There have also been consultations with the SADC PF committees themselves. And also there's been consultations with the regional police body, SAPCO, as well as the legal drafters in the region. So the idea is to ensure that as much as possible, the views of these stakeholders are taken into account in finalizing the model law, but also to ensure that there's awareness in the region and also ownership of the model law, because it's hoped that at the 50th plenary assembly of the forum, which is due to take place later this year, and maybe around December, the model law will be presented for adoption, and hopefully the forum will adopt it. And once that is done, it will hopefully provide a guide for the legislatures and the member states of the SADC region to pick and to adapt to their local, to domestic legislation to meet those standards that are set out in the model law. So today, the meeting is aimed at ensuring that various other partners, especially UN organizations, the UN family, and other partners are brought on board, and also that they add their voice to this discussion. And that's the idea of today's meeting. So without much ado, it's my honor to invite the Secretary General of the SADC Parliamentary Forum to deliver her welcome address. Madam Secretary General.
I'm sorry, I was muted all along and I was going on. Okay, thank you very much. Am I audible now?
Yes, ma'am, you are.
Oh, thank you very much. Thank you, Director of Ceremonies, for that kind introduction to the process. Let me observe protocol and welcome Dr. Sarah Thompson, the lead policy specialist for health and sexual reproductive health and rights, based in Sweden with SIDA. Let me also recognize Dr. Bennett Nyanabangi, the Regional Director, UNFPA, East and Southern Africa region. Welcome, sir, to the region, and congratulations for your recent appointment. Allow me to also recognize Ms. Eva Jala, who is our revered legal drafter of the Gender-Based Violence Model Law, colleagues from national parliaments here present, and those from the SADC Parliamentary Forum, and members of the media. Dear colleagues and distinguished participants, it's with pleasure and gratitude that I humbly welcome you to this consultation in my capacity as the Secretary General of the SADC Parliamentary Forum. This consultation today involves you, who we consider as partners and friends of the SADC Parliamentary Forum. It also includes Sweden, a key partner for many years of the forum, the UN agencies who've worked with the forum as technical partners and backstopping on various thematic issues, as well as other development partners who've worked with us in areas of governance, food security, among others, and who have immensely contributed to the human and social development of the SADC region, including through gender-based related programs and initiatives. Dear colleagues and partners, since the establishment of the forum more than 2 decades ago, regional and international partners of the forum have been on the forefront of shared initiatives, which have aimed to infuse best practices to the SADC region. This forms part of the forum's commitment to implement sexual reproductive health and rights and governance interventions, also to implement a culture of human rights through interparliamentary cooperation. And in so doing, it was imperative to implement the Universal Declaration of Human Rights of 1948 and the International Covenant for Civil and Political Rights of 1977, as well as the International Covenant for Economic, Social, and Cultural Rights of 1977. Certainly, similar legal norms have evolved at the regional level through the African Charter on Human and People's Rights of 1986 and its protocol on the rights of women in Africa, to cite a few. Indeed, through the diverse initiatives of the forum and its partners, the SADC Parliamentary Forum, together with its member parliaments, have over the years succeeded to progressively incorporate international norms and best practices found in instruments that I've just mentioned into domestic law. And this with close collaboration of its development partners represented here and those who have not been able to make it. Dear colleagues, friends, and partners, in this respect, model laws have always constituted an avenue to propel international and regional norms into the legislative calendar of member states. SADC model laws, as we know them, have found their way into domestic legal systems within SADC, as well as acted as useful benchmarks and guiding references for legal systems outside of SADC and across Africa. In addition, SADC model laws have influenced domestic laws and regional frameworks across the continent. In this respect, the visibility of the model laws, as well as the impetus for advocacy of same, have been largely heightened by development partners of the forum, including through programs that have been funded by Sweden. We also have benefited from the UN agencies and other donors. Through such partners, the model laws have known a ripple effect across the SADC region and outside our borders in the SADC region. Colleagues, I seize this opportunity to express gratitude to all partners who have left no stone unturned to contribute to develop model laws, who have contributed to producing advocacy content for the engagement of members of parliament, or go further by inviting the forum to disseminate the model laws during thematic international meetings. Colleagues, now turning to the topic we are here for today, we are yet again developing a SADC model law today. The SADC model law on gender-based violence and this consultative process would not have been complete without your input and engagement. As you may be aware, this consultation formed part of a series of consultations, as the Director of Ceremonies has already indicated, and it will go further to contribute to the alignment of laws at country level, with international best practice at the heart of this process, as witnessed in our previous model laws that we have developed on eradicating child marriages, on elections, on HIV and AIDS, among others. It will be a benchmark. It will be a gold standard. And today we meet with you as partners of the forum who are technical in some of these areas to mainly seek to reflect and brainstorm on how to carry the model law forward. In other words, as we finalize this model law as a bespoke legal instrument that neutralizes gender-based violence in the region, there's a need to consider how partners, friends, the UN agencies and Sweden can assist the forum to make early gains on the model law once it's adopted this year in December. Dear friends and colleagues, before I proceed to the post-model law agenda, I wish to give further context to partners about how the SADC model law intertwines with other regional policies. And this is in order to demonstrate that investing into a post-model law initiative will also help fructify other initiatives that aim to promote sexual reproductive health and rights and gender equality. The SADC model law on gender-based violence is an initiative that sprang from the stem of the Forum's strategic plan of 2019 to 2023. Indeed, the strategic objectives of the Forum are geared towards promoting gender equality, implementing public health and universal health coverage, as well as guiding the SADC region towards a culture of human rights within a democratic context. You will certainly concur with me that there can be no human and social development in an environment that is polluted by gender-based violence. Universal health coverage, as well as the promotion of sexual reproductive health and rights, do not sit well with gender-based violence to any degree. And the right to physical integrity of individuals is for its part completely abhorrent of gender-based violence. Dear colleagues, from this angle, it was opined by the Forum's membership that the model law on gender-based violence could be the sword that could effectively vanquish cross-cutting social ills and leave the way open for sexual reproductive health and rights, human rights, and universal health coverage to finally thrive. Since parliaments are the exclusive sovereign authorities that are empowered to legislate in SADC member states, it thus stands to reason that all gender-based violence policies need to be channeled through the parliament if such policies are to have any legal effect. The SADC model law on GBV was thus perceived as a legal remedy that would constitute the pinnacle of regional efforts towards eradicating gender-based violence. Eliminating gender-based violence in the SADC region will thus assist the Forum to draw one step closer to the implementation of universal health coverage and to build foundations for the democratic drive to be accelerated and reinforced. Dear colleagues, since you as international and regional partners are also involved in other regional initiatives concerning GBV, it is important for me to emphasize that the SADC model law on GBV is not a self-standing regional measure, in the midst of other SADC initiatives. Indeed, this model law is in harmony with the broader SADC regional strategy and framework of action for addressing gender-based violence, which many of you have indeed contributed to finalize. Whereas the SADC regional strategy for GBV calls for human rights compliant legislative provisions which outlaw all forms of GBV, the SADC model law on GBV can and is an extrapolation of the regional strategy which aims to facilitate the establishment of enabling GBV legislative frameworks in member states. The model law, colleagues, reiterates the gender-related objectives under the SADC Protocol on Gender and Development and its addendum, the Sustainable Development Goal number 5 on gender equality, the Beijing Declaration, as well as Aspiration 6 of Africa Agenda 2063 on women and youth empowerment. The model law on GBV is thus poised to act as a catalytic accelerator for the GBV commitments taken by member states under the various international covenants I mentioned earlier. Dear colleagues, on this note, I wish to add that the efficacy of SADC model laws to facilitate domestication is undisputed. As partners operating at the regional level, it is no secret that all we are all struggling with on the issue of domestication is real. The domestication of treaties and norms has always been a struggle in most of our countries, since most member states are dualist in nature. International law has to be domesticated by an act of parliament for it to have any binding effect at the national level. In this respect, the SADC model law on GBV too will need to be domesticated. However, the Forum has already planned ahead for the domestication process in tandem with its oversight organ, the Regional Parliamentary Model Laws Oversight Committee, which is mandated to monitor the domestication of model laws developed by the Forum. Therefore, the adoption of the model law by the plenary assembly, the 50th plenary assembly of the Forum, will augur a new dawn for domestication of gender-based violence norms. We invite you to take interest and walk with us in this path. Dear colleagues and distinguished participants, having spoken on the germane importance of the model law, and I wish to say a few words on the post-model law agenda, in which the Forum will require your input and reflections. As you are all aware, the model law is not an end in itself, but the beginning of a promising journey. If we want progress to be made, we must invest now for gains to be made later. We therefore require your input on how best the Forum can enhance this partnership framework and benefit from the partners' resources to advance the model law further through programs and initiatives that ensure domestication and enforcement. Whether it is by the development of advocacy material, media articles, sensitization campaigns, the model law on GBV needs to be vulgarized within the SADC region. The Forum is in favor of innovation and is currently considering all forms of advocacy materials with civil society organizations, with partners like yourself, including looking into animated videos in all the multiple languages in the SADC regions, or looking at comics to fulfill the post-model law agenda and ensure that GBV best practices infiltrates into our domestic law systems. At the same time, colleagues, I'm pleased to inform you that today the Forum's transformation into a SADC parliament has been approved in principle by the 41st SADC Summit of Heads of States and Government on the 18th of August 2021. Colleagues, this means basically that the Forum will ascend to a parliament within an estimated period of 2 years, according to the roadmap, when the SADC protocol establishing the SADC Parliament has been ratified and adopted by member states. The SADC Parliament will then become an institutional organ of SADC under Article 9.1 of the SADC Treaty. This welcome development augurs well for the model laws of the Forum, as the SADC Parliament will have further thrust to push for domestication in collaboration with its member parliaments. Partners like yourself present here today are thus invited to reflect on how best they can contribute and participate in the post-model law development agenda, such that the momentum of the model law is not lost and culminates into tangible results against the backdrop of the transformation of the Forum. Dear colleagues, I wish to end by saying that the Forum has always been a fervent enabler of participatory democracy. And today, your contributions as participants is also a means for the Forum to promote participatory democracy at the regional and international level. Today, the world is a global village with technology binding us together. And in this global village, participatory democracy entails that the views of stakeholders at the regional and international level are as important as views garnered at the national level. This meeting is thus important because you are important to us as well as well-wishers of the Forum and the safe custodians of democracy at the regional level and international level. On this note, I humbly wish to thank you again for your attendance and wish you all a pleasant session. Thank you, Director of Ceremonies.
Thank you, Madam SG. And thank you for that very enlightening address, which reminded us that model laws actually can have a ripple effect in improving matters, particularly matters of gender equality in our region, and could also help vanquish various social ills and help the region or spur the region towards achievement of its development goals. I think also SG has reminded us that our partners, who are most of them or many of them are here today, have contributed to the development of model laws by the Forum and dissemination of the contents of such model laws at various fora. She also called on all our partners to continue to work with us on the journey of overseeing or oversight of the process of domestication through various programs and activities of the Forum. Thank you again, SG, for that speech, that address. And at this juncture, I would like to call upon the legal drafter, Mrs. Eva Jala, our esteemed legal drafter, to actually make a presentation of the model law to the participants. Mrs. Jala.
Apologies, Madam Claire.
Yes, ma'am.
I think you're looking at the wrong program. We are supposed to be now inviting our keynote address.
Oh, yes, Mrs. Sarah.
Yes,
sorry, I think I missed it. Mrs. Sarah Thompson, the lead policy specialist for health and SRHR SIDA, to deliver a keynote address. Thank you. Dr. Thompson.
Thank you. Madam Secretary General of SADC Parliamentarian Forum, Development Cooperation Partners, United Nations colleagues, and staff of Parliament. Thank you for the opportunity to attend and participate in this regional consultative process to provide input into the drafted SADC model law on gender-based violence. Gender-based violence, or GBV, remains an important issue globally. According to recent analyses of prevalence data by WHO, nearly 1 in 3, or 30% of women worldwide, have been subjected to physical and/or sexual violence by an intimate partner or non-partner or both. GBV is explicitly incorporated in Sustainable Development Goal 5 to achieve gender equality and empower all women and girls. GBV is also recognized continentally in Aspiration 6 of Agenda 2063, an Africa whose development is people-driven, relying on the potential of African people, especially its women and youth, and caring for children. And not least regionally, via SADC Protocol on Gender Development, through which the protocol aims to provide for the empowerment of women, to eliminate discrimination, and achieve gender equality by encouraging and harmonizing the development and implementation of gender-responsive legislative, policies, programs, and projects. Sweden has a long-standing commitment to gender equality and women's and girls' empowerment in development cooperation and humanitarian assistance. Through Sweden's feminist foreign policy established in 2014, Sweden promotes an agenda for change to strengthen the rights, representation, and resources of all women and girls. Gender equality is a fundamental aim of Swedish foreign policy. Ensuring that women and girls enjoy fundamental human rights is an obligation within our international commitments and prerequisite to achieving Sweden's broader foreign policy goals, which are peace, security, and sustainable development. Sweden applauds SADC Parliamentarian Forum's current efforts towards the development of a model law on gender-based violence. We note that the current model law on eradicating child marriage and protecting children already in marriage has enabled legal reforms with regard to the age of consent to marriage, which has been changed in Malawi and Mozambique, and soon in Zimbabwe. Sweden sees the institution of parliament and parliamentarians as critical to advance the sexual and reproductive health and rights of women and girls in the region, not least as agents of change, and for holding the executive accountable for the multiple regional and global commitments, which are still far too seldom fully domesticated and implemented. Most importantly, national laws, policies, and strategies that are not fully recognized or implemented by duty bearers. Through our partnership with SADC-PF and other partners in sub-Saharan Africa, Sweden is proud to be supporting efforts in the region that aim to address GBV through advocacy work to enforce existing laws and policies, through tackling social and gender norms that hinder progress on the elimination of GBV, and data collection to raise awareness and to inform duty bearers and policymakers. Sweden recognizes the extensive consultative process with all key stakeholders to ensure the GBV model is all-inclusive. We would like to particularly underline the need for domestication of the GBV model law once adopted, and stronger mechanisms to hold member states to account in order for enforcement and enactment to take place at national level. The legislative function of national parliaments would therefore need to be impelled to ensure that domestication of the GBV model law is done as a matter of priority. 2020 was meant to be a milestone year for gender equality. However, progress has reversed. COVID-19 has affected everyone, but particularly women and girls. Lockdowns during the COVID-19 pandemic and its social and economic impacts have increased the exposure of women to abusive partners and known risk factors, while limiting their access to services. Current reports indicate that GBV, particularly domestic violence, has indeed increased during the pandemic. Therefore, there couldn't be a better time for the development and finalization of the GBV model. I wish you a fruitful deliberation.
Thank you, Dr. Thompson, for that illuminating keynote address. And I think Dr. Thompson has once again brought to the fore the need for domestication. Just like Secretary General had indicated, the model law is not an end in itself. There is need to go further, and the forum is well placed to continue to push for the domestication of the benchmarks or the standards that are set in the model law. And Once again, I apologize for the oversight earlier. And now it's my honor once again to call upon Mrs. Eva Jala, the legal drafter, to present the model law on gender-based violence. Mrs. Jala.
Thank you very much, Madam Moderator. If I can share the screen now. Please, can the technicians allow me to share my screen?
You can share the screen.
Yeah. Good morning, everyone. I hope you can now see my screen. May I begin by observing the protocols? SG, distinguished participants, donors, ladies and gentlemen, may I simply say all protocols observed as pronounced by SG. Before I start my presentation, I would wish on how I developed the SADC GBV model in line with the terms of reference that I was given, taking into account certain researched factors, legal concepts, and principles, mainly from the common law and the constitutions of member states, the UN and SADC tools, and international instruments, which contain the obligations of states on GBV. So basically, those are the factors that I took into account. The model law is very comprehensive, as you can all observe, not only in terms of size, but also in the depth of its propositions. In developing the model law, I worked very closely with the SADC PF Secretariat and the technical working group that was set up to give direction and purpose to the assignment, and also provide expert input into the propositions in addition. I'm sorry, is it, am I still being heard? Hello?
You are.
Good
Yes,
morning.
ma'am.
We can hear you, Mrs. Jala.
Oh, okay. I thought I had gone off at one point. And also give input into the propositions being developed. The GBV model law is soft law, as the SG has already pronounced on. It sets a gold standard to be achieved by member states, as it embraces best international and regional practices on how to deal with GBV as part of the criminal and administrative justice systems, with an aim of ensuring access to justice for all victims of GBV. The model law has been developed in such a manner as to be persuasive to SADC member states, as it points out a number of lacuna and fragmentation based on in-depth research in their national laws dealing with GBV and provides for efficacious or adopted in member states' national laws. I basically took a law. The first was a gender-sensitive approach, and secondly, a human rights-based approach. And this you can see reflected in the entire breadth of the model law. The member states are encouraged to domesticate the model law and have provided in the model law requisite guidelines on how this can be done, whether holistically or progressively. The session so far, as you have been very successful, and we've had positive response to the GBV model law. And it was interesting to hear about or to see the reactions of certain member states on matters such as homosexuality, lesbianism, and so forth. Some member states had problems with those issues, but we urged them on to engage effectively with other member states to see how everyone in their societies can be included under the protection of an effective GBV model law. So it was quite interesting. They also expressed quite a lot of concern on the full domestication of the model law. But again, we explained to them that they can still do it progressively in accordance with their constitutional systems until such a time as they amend their constitutions on those issues. So there were quite a number of enlightening expositions by member states, which you shall all see when we finally do the report on the consultative process and some of the issues that may have to change in the model law, but not to defeat the spirit of the model law, which will remain intact. With those few explanations, I can't put on my video because it has been stopped, and I hope that's okay with all of you, because I think the technicians have stopped my video. So I'll continue. I noticed they've started the video again. Okay. So what is the GBV model law in relation to the systems of those pertaining in member states currently? The model law seeks to guide SADC member states in developing effective policies and efficacious laws on gender-based violence. It's a tool, it's a guiding tool in the form of soft law. It's persuasive to changing GBV laws as they exist in member states. The GBV model law is not designed in the exact style and form of legislation in member states. It is designed in such a manner as to communicate clearly the policy content and recommendations on best practice legislative provisions for inclusion in an efficacious national law on GBV. So that's the intent of the model law. We are not usurping the powers of national legislatures, but we are enhancing the content of possible laws. Therefore, the GBV model law will be a useful tool to member states as it will provide some of the following. Obviously, we can't exhaust all the advantages of the model law, of using the model law, but we can point out essential issues that must be taken into account. Guidance on the scope and content of GBV provisions to be provided in the national laws. We understand, Madam SG, Madam Moderator, that most member states have problems in coming up with efficacious content. Efficacious content. And that's the reason why most of their laws are very framework in nature, which don't help the victim, the service provider, and all other users of the model law in applying or implementing its provisions efficaciously. The model law is also a useful tool in encouraging national legislatures to enact GBV laws where these do not exist at all, or where they do exist but do not conform with this model law, to revise such laws and enact relevant GBV laws that conform with the basic tenets of the GBV model law. It will support national laws during implementation stage, especially where gaps exist in national laws. Sometimes due to lack of a proper regulatory regime, you find that implementation becomes a problem. And the impact that the legislature intended to have when it enacted the GBV model law is lost during implementation. So this model law, due to the nature of its content, may help to actually implement or operationalize the general framework for dealing with GBV. The model law is a yardstick to national policy analysts, legislators, and implementers as to best practices in enacting and dealing with GBV. It's put forward to assist them develop policy provisions to support an efficacious, well-grounded legislative framework on GBV. It will also reinforce a commonality of a regional approach in dealing with GBV laws, measures and strategies to help eliminate GBV. And when we come to the provisions later, key provisions, you'll see how we've dealt with this commonality approach. we've put in effective application provisions. We've put in effective extraterritorial provisions in order to ensure that GBV is tackled across borders, leaving no one behind. The GBV model law will also stimulate debate, awareness, and advocacy, which is fundamental in promoting its tenets. Let us look at the rationale and objectives of the law. So, as a governance tool, as I said earlier, it will help member states to meet their international, continental, and regional commitments relating to human rights, and more specifically, against gender-based violence. As we know, human rights, the rule of law, and its observance is one of the most important instrumentalities of the state. There are 5 instrumentalities, and the first one is observance of the rule of law, which includes constitutionalism and the human rights and freedoms of the peoples living in their jurisdictions. The underlying rationale is to protect victims and probable victims of GBV, punish perpetrators, and ensure that human rights are upheld in accordance with international, continental, and regional standards and requirements. As you are aware, and I need not overemphasize this, is that GBV covers domestic violence, sexual harassment in the workplace, human trafficking, and sexual and emotional abuse, economic violence, only to name a few. And we shall see these reflected in the definitions of the UN, of SADC, that we used for purposes of developing this model law. So, when referring to GBV, the discussion should not only be of the act of violence, but also about education and prevention, as well as victim assistance. As GBV not only has terrible effects on the victim, but impacts negatively on society at large, with serious social and economic consequences. So we need to deal with it on a large scale, on a large base, a wider perspective. If not, the fight against GBV will be futile, because it is a national issue which requires drastic national interventions through the highest tool of governance, the law. The law. There's no other tool of governance that can be more effective than the law. To mobilize people into actions, to ensure that the state provides sanction for non-observance, and to ensure compliance. Without the nexus of the law, then the effort is futile. Let us turn now to your own definitions of what GBV is and that of SADC, which is very similar in nature. The UN defines GBV as any act of gender-based violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or in private life. Turning to the SADC definition, which is all acts perpetrated against women, men, boys, and girls on the basis of their sex, which causes or could cause them physical, sexual, psychological, emotional, or economic harm, including the threat to take such acts or to undertake the imposition of arbitrary restrictions on or deprivation of fundamental freedoms in private or public life in peacetime and during situations of armed or other forms of conflict. You shall observe, or you have already observed from reading the model law, that we make a combination of the two. And we amplify the provisions in our definition section, our interpretation section. May I, distinguished participants, take you through the research that we did on national laws on GBV, very briefly. We found that the majority of SADC member states have laws in one form or the other dealing with some forms and components of GBV. These do not seem to be stemming or eradicating GBV, maybe because of their selective nature. They don't deal comprehensively with issues of GBV or the various stages in the administrative or criminal justice system or process, as you would or you know it better being called. We found a lot of inadequacies in such legislation. For example, their legislation have certain loopholes, what we would call lacuna in the legislation. The provisions lack scope or content, and that's the major concern. That's why the GBV model law concentrates on building a lot of content that can be used by member states. The laws are at most fragmented, inconsistent, conflict in allocation of mandates, bringing in paralysis. Who is supposed to do what at any one time? Some of them are ambiguous or generally vague as to meaning, making implementation very difficult, making it difficult for the courts to interpret adequately their provisions. They do not clearly bring out the privilege, the entitlement, or the rights of victims. The legislation further lack adequate access to justice provisions. And this we found very critical. Most of them do not specify or come out clearly in relation to access to justice, to enable and ensure that the various players in the criminal justice and administrative systems at various stages prevent, receive, investigate, attend, prosecute, and decide on GBV cases efficaciously, practically, and timely. And lastly, enforce decisions made on GBV cases and ensure protection of victims of GBV. Legislation in member states lack adequate compliance and enforcement measures. This, as you know, renders the law inefficacious and not having the impact it was intended to have. The laws lack adequate provisions to ensure sufficient and sustainable resources, resulting in lack of administrative and financial capacity to deal with GBV. Without resources, it becomes very difficult to implement any law on GBV, as a lot is required. A lot is required, whether it's in terms of infrastructure provision, advocacy, awareness, or handling, assessing, investigating GBV cases. It requires a lot of resources. We do understand that some governments don't have such resources. But if the law compels the allocation in budgetary allocations, some form of resources, it goes a long way in fighting GBV. The laws lack provisions acknowledging and addressing the nexus between statelessness and GBV. On the one hand, forced migration and GBV on the other hand. Asylum seekers, migrants, and those on the move on the other hand. They hardly recognize persons without documentation. And this is widespread amongst member states' legislation. And this will bring us to the discussion of the institutional frameworks in member states' legislative systems. We found this to be rather weak for various reasons. Currently, issues related to GBV are regulated and managed by various ministries and statutory authorities with complementary support from the private sector, especially civil society organizations. In most member states, there are no independent single regulators or management units dealing exclusively with matters relating to or impacting on GBV. The institutional frameworks in most member states include gender commissions, prosecution authorities, legal aid services, women's clinics, the police service, victim support units, the judiciary, civil society organization, and workforce and institutional-based units. Without an efficacious institutional framework, it is very difficult to deal with GBV cases, because for effective and efficacious handling of GBV cases, member states will require legislative and institutional frameworks that provide adequate measures, strategies, programs, and interventions which are well corroborative to deal with GBV, including providing adequate capacity building for critical role players and stakeholders, so that they can render effective and sustainable prevention, monitoring, and management services for GBV. And without such a collaborative and well-trained institutional frameworks, then it becomes futile once more. It becomes difficult. So it's so important that member states are assisted in providing adequate institutional frameworks for engagement of all players who regulate, manage, and are affected by GBV, by ensuring a clear system for coordination, communication, and collaboration, including consultation among all the players. And these should have clear lines of reporting and responsibilities. Otherwise, we create paralysis in the institutional system, and as a result, GBV cases are either not taken seriously or not dealt with at all. And where they are dealt with, their management is very weak, very weak. And access to justice to the victims is actually denied. Therefore, the regulatory and institutional framework must be clear and certain on issues such as extent of regulatory and investigative powers, functions and duties of key role players, procedural requirements, access to justice, coordination, communication, and collaborative issues, enforcement and compliant mechanisms, and management of infrastructure facility, amongst others. We have endeavored in this model law to ensure that these are properly legislated. The propositions have been well crafted in a manner that national parliaments or national executives can merely copy and paste with very minor adjustments. It is important that victims of GBV and the private sector involved in providing advice, assistance, and protection to victims of GBV are assured are assured, because of the nature of the legislative framework, that regulatory state authorities have the necessary autonomy, power, and capacity to act fairly, transparently, and decisively when responding to GBV cases. Without this assurance, the persons who want to assist, whether in terms of financial resources, technical resources, or advocacy, will find it very difficult to do so. The law must be certain. And we've tried as far as it is possible to create this autonomy, to ensure that such capacities will be built, to ensure that the processes and procedures are fair and will decisively respond to GBV in all its respects. It's important, dear participants, that you see how we've made a paradigm shift in the way laws should deal with GBV cases. We've used a four-pronged approach towards achieving this paradigm shift for purposes of handling GBV. And we are hoping that member states can do likewise when coming up with their national laws. For example, these are mere examples. We have provided a human rights-based approach to GBV laws that address the root causes of GBV and allows for inclusion of all marginalized groups, including refugees, asylum seekers, stateless persons, and persons without documentation, and migrants, and ensure that such approach is actually applied by all respondents. And we think this is very important because that is what most legislation in member states lack. They lack this nexus. We try to interface all concepts, rules, and principles of access to justice to promote a seamless connectivity for efficient handling, investigating, prevention, prosecution, protection, and enforcement of all GBV cases. Further, we've introduced innovative methods to deal effectively with GBV, especially in these times of COVID-19. We all understand what closed spaces can do in promoting GBV, and we try to tackle this aspect of GBV. Another approach is to ensure adequate information and financial resources are provided in the legislation for intervention, prevention, protection, enforcement, regulation, and measures that will work and be maintained and that will be sustainable. We've tried as much as possible to ensure that budgetary allocation is actually done for these specific areas instead of relying on generalized budgeting for a ministry or an institution. Members, we did look very carefully in the constitutions of member states as far as human rights is concerned. We have cognizance of the fact that most member states use their constitutions for not domesticating or applying certain rules and principles for special purposes of GBV cases. We recognize that certain principles established in the constitutions are difficult to change and take a long period of time. But this should not stop member states in trying to remove archaic concepts and principles so that they bring justice to victims of GBV. So yes, we took into account when drafting this model law that national laws must also take into account the constitutional principles. But that did not stop us in the model law to coming up with principles and concepts to defeat the archaic principles and concepts leaning on evidentiality rules. The aim is to persuade member states to change by law certain of the concepts which are archaic, the principles which defeat access to justice by progressively removing them from their constitutions and enacting effective laws to protect its citizens. Most of them will use the principles of intravirus and ultravirus applicable to primary and subordinate legislation, and they will be observed by national drafters. But again, national drafters will not be able to ensure justice if some of those rules are not changed. Yes, most member states have Bill of Rights embedded in their constitutions, which, though not comprehensive in certain cases, follow closely the human rights spelled out in the Universal Declaration of Human Rights. International human rights instruments provide an agreed set of human rights standards, as you all know, and establish mechanisms to monitor the manner in which human rights and freedoms are implemented. And member states are aware of these facts. But those member states without contemporary constitutions have not expanded on their Bill of Rights and still use the traditional standards, which could affect the fight against GBV, could affect progressive provisions to be enacted in the statute law dealing with GBV. And with the domestication of the model law, they will need to relook at their Bill of Rights, because that's where most of the problem stems from, especially for evidentiality rules. We also have pointed out in the GBV model law key human rights treaties of the UN that must be taken into account when coming up with an efficacious law on GBV. And these include the following: the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women. I need not read all of them. I'm sure you have had a chance to look at the explanatory notes and the preamble to the model law, and you'll see that we've included a vast array of these treaties. So the model law attempts to restate some of these human rights as they directly impact on GBV. We've informed our member states that these are no way exhaustive, and that the drafters of their national legislation should endeavor to summarize all their state obligations at international level, analyze this, and fill in the gaps in their national laws where they exist. We've also pointed out to them, dear participants, the need to use certain UN and SADC tools. As the UN has issued, as you know, a number of legislative guidelines, guidance notes, explanatory notes, and commentaries on various human rights instruments, which act as good working tools to their drafters of national legislation for gap analysis on national laws impacting on GBV. And we've explained to them very clearly that some of the main recommendations made in these guidance notes, explanatory notes, etc., have actually been incorporated in this GBV model law. And we explained that while taking into account the recommendations made in UN commentaries, we've actually taken cognizance of their constitutional requirements. And this was to assure them that we are not actually doing anything ultra vires their constitutions, but complementing such provisions. We also pointed out to them, especially the drafters of national legislation, that they may wish to refer to regional and international guidelines and recommended practices that provide for police and law enforcement duties and responsibilities. For example, the Essential Services Package, ESP, which is a guiding tool that identifies the essential services to be provided to all women and girls who have experienced gender-based violence, including services that should be provided by the health, social services, police, and justice sectors. We've pointed out to them that we have tried as far as is possible to include some of these provisions in their model law for ease of drafting by themselves. Because we understand that they may not have a lot of time to do in-depth research. So we have done the research for them, and we have come up with a holistic model law on GBV. We've explained to them that the package, the ESP package, also provides guidelines for the coordination of these services. It provides standards and guidelines for health personnel, police and justice players, social and health services, and for coordination and governance of these. And that SADC has similar guidelines for the region. Because we have observed, and we've actually emphasized this aspect, that the institutional governance relating to GBV is very weakly dealt with in their laws. It is like it's a passover. They just quickly pass over it and go to the criminal aspects of GBV, which is not very helpful in managing GBV. We've also urged them to consider a range of enforcement and compliance provisions to give effect to the GBV model law and effectively prevent or deter GBV happening. The following key factors were to be considered and reviewed when crafting their GBV provisions. The extent to which the root causes of GBV are addressed with a view of migrating or eradicating them. The extent and nature to which GBV is provided in criminal and administrative law. Whether GBV offenses provided for contravene fundamental provisions and the language of this GBV model law. We emphasized the importance of this particular one, so that to ensure commonality in the legislation in the region. Whether the offense of GBV is provided for in the law and what the extent of the prohibitions are. We find that some member states, yes, they have a law on GBV, but their provisions do not clearly come out with offenses and the extent of what the prohibitions are. There's a lot of confusion in this respect. Whether the offenses, penalties, and compensation provisions are adequate and fit the offense specified. Whether adequate investigation powers are provided for to enable evidence to be easily gathered, assessed, and used to obtain a conviction for a GBV offense. Whether procedural fairness and justice are firmly embedded in the law, and whether there is commitment to address impunity and delays in the course of justice. I'm sure you as donors have come across these complaints from victims, from civil society, as to the impunity of the police, some service providers in the health sector, in the education sector, and so forth, that will do anything to defeat the cause of justice when it comes to GBV. We explained that an inefficacious legislative framework on GBV may result in increase in GBV cases, lack of access to justice, and continued inequities and inequalities in society, thereby having a negative impact on socio-economic development, and continued non-observance and contravention of an individual's fundamental human rights and freedoms. And once we touch on the impact on socio-economic development, we see that they do sit up. They sit up because they know without socio-economic development, they cannot achieve a welfare society. A society in which every person is worth something. Every person is equal before the law. Every person is equitably treated. And that finally, and most important, that the state will achieve its first instrumentality, which is fundamental human rights and freedoms, and can be held accountable for that. The model law is a special type of law. If you look closely at its content, it is well crafted to include all substantive provisions as well as regulatory provisions, as well as operational administrative provisions. And we've done it in a manner in which will take into account regional specificities. Certain issues that will apply to certain states. We've ensured that the manner it was crafted is based on solid policy and includes comprehensive measures, interventions, and administrative support systems, procedures, and processes to be exercised either in the substantive act or under subsidiary legislation, so that it is an effective implementation tool. We didn't want to leave gaps for member states to say that, no, this is, we can, okay, operationalize the model law, but we don't have technical content to operationalize the act into regulations for better implementation. So we included both substantive issues and subsidiary matters to guide member states on the entire extent of the law to be enacted by national legislators and to issue executive regulations or orders for its full implementation. We've also looked closely at customary laws and religious norms, because we are cognizant of the fact that these may impact greatly on women's and children's human rights, offend international commitments on GBV, good governance, and some may be repugnant to natural justice and legal justice. We found from our research that customary laws are recognized as a source of law in most member states, where they are not inconsistent with a constitution or an act of parliament, or are not repugnant to natural justice. We also found that most constitutions of member states recognize the freedom of religion. And we have urged all the participants that attended our workshops that their member states need to assess these customary laws, religious norms, and practices, and attended institutions where these are contrary to the model law or repugnant to natural justice, and reform them, amend them, so that they comply with the model law, without fighting customary laws and religious laws and dealing with them objectively, and expunge the offending ones from our legal systems, we may not succeed in the fight against GBV. And one of the participants, I think it was someone, a lady from Tanzania, brought out this fact that, why did you put such a thing? Because we've got our own values, our own customs. How can we go against this? And that has to be explained to her by the SG, who did it very effectively. An important issue which the SG has already touched on is the issue of domestication and internationally used terms. We brought to the attention of member states that they are obliged by the terms of the Vienna Convention on the Law of Treaties of 1969, which obligates them to abide by their international commitments. Their municipal laws are not excuses, cannot be given as an excuse for them not to implement their international obligations. So we've provided in the GBV model law guidance for the domestication of the various regional and international instruments on GBV in accordance with their commitments under regional and international instruments on GBV. The GBV model law urges them to embark on legislative reforms for purposes of giving effect to their international and regional obligations and commitments, which are generally incorporated as requirements, principles, concepts, standards, measures, interventions, and programs. And that should the GBV model law be adopted by SADC PF, which it will be, as we've been informed, in December, they need to domesticate it, even though the domestication processes will depend on national legislative or executive action, which will take time using the authorized processes and procedures. But this should be done. We understood and we acknowledge this to them, that we understand that domestication will depend on and evolve according to the requirements and complexities of their national constitutional requirements and processes, which may vary among member states, as some use the dualist concept, while others have a self-executing system, a monist, for the domestication of international obligations. But we guided them as to the easiest and most effective methods for incorporating international law, such as reflecting the principles of their content or text in their national laws, either directly or in a contextualized manner, setting out the text in the national law itself, either in full or in part, giving full effect to regional or international instruments by reference annexing the instrument as a schedule to the national law or a combination of both. We pointed out to our stakeholders that the GBV model law uses a number of words and terms defined in regional and international instruments on GBV. And where this is used, these are defined as provided in those regional or international instruments, with only some modification to achieve simplicity and ease of understanding. And urge them that when adapting these into national legislation, they should reflect the most up-to-date terminology in the field used in the protocols to these conventions. Participants, we have provided, or we've attempted to provide in the GBV model law, areas of competence. And we've allocated the competence to the most appropriate authority, competent authority, judicial institution, or quasi-judicial body, and have defined these terms for effective and efficient decision making. And where discretion is given, we've tried to ensure that this discretion is exercised proportionately or comparably in relation to the nature of the decision being made. We've urged that these authorities must act in a manner which affords procedural fairness to victims of GBV and must be and appear to be free from bias. Our countries are still suffering from gender bias, which has a knock-on effects on socioeconomic development. Survivors and victims of GBV must be given a fair opportunity to provide any relevant information before a decision is arrived at. And that decision must be explained in a way the victim of GBV can easily understand, regardless of their background, nationality, or lack thereof. This area, participants, was a very difficult area for most of our participants. The focus of the GBV model law seems to be more on violence against women and girls, but we've pointed out that the GBV model law also has a gender-based approach. It applies and is of relevance to violence against men and women, boys and girls. We've advised and pointed out the provisions in the model law, which reads the model law very broadly to apply to all forms and components of GBV. to the extent of the UN and SADC definitions. To all victims and perpetrators of GBV, be it non-gender binary people, heterosexual, lesbian, bisexual, homosexual, transgender, or people within same-sex relationships or sex workers. Some of our member states had problems with this, pointing to customs, values, cultures, and their constitutions. We emphasized that in general, regardless of orientation and occupation, women and girls are more vulnerable to and experience more sexual violence, more severe physical violence, more abuse, and more control, largely from males. And that's the reason acute focus is made on women and girls who are disproportionately affected by GBV. We also pointed out that the underlying logic of the subject areas of the GBV model law bear in mind the various categories of users of the GBV model law who will be responsible in member states for developing, drafting, approving, enacting, and implementing the GBV model law, or who have an interest in monitoring and evaluating the efficaciousness or impact of the GBV model law. So it's a very coherent law. It takes an all-government approach in dealing with GBV. I won't take you through, and because you already know what the SADC concept paper relating to the coming up of the SADC model law is. So I'll skip these provisions. But what was important in the main was to address in the GBV model law, CEDAW General Recommendation number 35, which was a milestone in this field, as it recognizes that the prohibition of gender-based violence has become a norm of international customary law, expands the understanding of violence to include violations of sexual and reproductive health rights. We needed to point that out. Stresses the need to change social norms and stereotypes that support violence in the context of a resurgence of narratives threatening the concept of gender equality in the name of culture, tradition, or religion. Clearly defines different levels of liability of the state for acts and omissions committed by its agents or those acting under its authority in the territory of the state or abroad, and for failing to act with due diligence to prevent violence at the hands of private individuals and companies, protect women and girls from it, and ensure access to remedies for survivors. Unequivocally calls for the repeal of all laws and policies that directly and indirectly excuse, condone, and facilitate violence, and emphasizes the need for approaches that promote and respect women's autonomy and decision-making in all spheres of life. So we pointed out that it was important that General Recommendation number 35 be used as a tool for accelerating the implementation of regional and international member states' obligations to eliminating gender-based violence against women, especially by incorporating the above recommendations into national policies dealing with gender-based violence. In brief, the Gender-Based Violence Act law creates a robust, inclusive, and uniform legislative framework relating to GBV. It is a key path to addressing GBV in SADC member states. The model law gives guidance to national legislatures on how to give effect to national policies, enact national laws, and hold national executives accountable in the implementation of strategic plans that aim at addressing GBV. The GBV model law endeavors to address GBV using a human rights-based approach with underpinning principles which are visible in the objectives, rationale, and principles of the GBV model law. I'm going to stop there now because I think time is not with us. You need to discuss it. And most of these issues you'll find in the model law, which I've taken that you've all read the model law. And you'll be able to engage with us to see which provisions we can improve on. We need your value additions in relation to the actual provisions of the model law. I just took time in bringing you up to speed on the development of the model law, what we took into account, and what we advised member states in relation to its enactment. Thank you very much.
Thank you, Mrs. Jala, for that presentation. Quite a packed presentation there. And I hope that the participants who have had an opportunity also to look at the model law, since it was shared earlier, have taken note of areas where they would want to comment. And now it's that time when their comments can now be received. You can, if you have questions, comments, additions, subtractions, any comments that would be useful in helping the drafter to shape the law to make it more efficacious, if you like. It's now time for those comments to be received. We'll be grateful. We're trying to monitor the participants on the screen, so we see you could indicate and raise your hand on the screen so that we see you. If anyone has anything to say right now. It would be helpful if you indicated.
Aubrey Ayenda.
I can't see any indications. Or am I missing something? I see Prajit Saha. I see a hand there, I think. You can please go ahead.
Good morning, good afternoon, colleagues. I hope. Am I?
You are cutting. We can hear you, but you are cutting. I am not sure about the connection, maybe.
Oh my God.
Okay. I will go back a little later. I have some problems.
Okay, maybe we can, yes, we will come back to you later. Could we have Amir Batenga? The next hand that I've seen.
Hello?
Yes, please.
Yes, good afternoon. Thank you. Thanks very much. presenter for the comprehensive presentation. It's really quite extensive, and I see it has addressed a lot of issues that we are struggling with in our countries regarding the GBV laws. And I know most of us are struggling with implementation of those laws. So going through the model law, I see it has given guidance on how best can we make sure that we formulate the efficacious laws, but also we do implement them on the ground to achieve the elimination of GBV. I had one or two comments, and one is on when we were presenting on the inadequacies of the institutional frameworks. I think one of the issue raised there was the having many sectors, many players, and dealing with the GBV mandate. And to me, I thought that this should be the strength for the, when you are looking at the institutional framework, this should be the strength because we need to work through multiple or many sectors and many actors and when we are dealing with GBV. But this came up as one of the inadequacies or the weakness within the institutional frameworks. I would like to get more elaboration on this. Thank you very much.
This one is done with the presentation.
Yes, Mrs. Jala, would you like to comment or to respond to that?
Thank you very much. Yes, indeed, it came out as a negative because of the lack of a comprehensive legal institution that ensures there's collaboration, communication, and consultation in the fight against GBV. You'll see that in most jurisdictions, these institutions tend to act as stand-alones without feeding into other institutions dealing with GBV. A women's clinic will take up a case, deal with the police, and then end up in court without understanding the other powers of institutions, especially the public institutions that could assist in furthering the interest of victims in relation to that case. So that in that sense, it's a big weakness. Yes, you can have many institutions dealing with GBV, but without proper coordination amongst themselves, the fight against GBV is weakened, especially where you find a clog in the system, in the process, and you are not able to unclog it due to the lack of information or a legislative proposition which will enable you to push forward the case without coming or dealing with obstacles such impunity, slowness in the process, non-responsiveness of the police or the health institutions, and so forth. So it's important to look at it holistically. Look at it as an all-government approach in the fight and not individual CSO fight or the police fight or being as an obstacle to GBV and so forth. It must be a coordinated institutional approach. That's when it's more effective. I hope I've answered your question.
Thank you, Mrs. Jala. Would Mr. Batenga, is Mr. Batenga okay? Or would you like to follow up on that?
Yes, thank you very much. I think she has addressed it very well, and thank you for
Okay.
that. Maybe if I can add one, I had two. If I can add one, it was on the. I was looking at the paradigm shift, and maybe with the leave no one behind principles, and I was looking at the provision for the vulnerable groups with multiple vulnerabilities, looking at the intersectionality dimension. I couldn't find, maybe it has been articulated in other way, but it would be very good if that could come up in the text. That how do you approach people with multiple intersectionalities, people having multiple vulnerabilities? Thank you.
Thank you. Would Mrs. Jala like to comment on that?
Okay, yes, if you read the GBV model closely, we have in nearly every provision dealing with access to justice ensured that these vulnerable, multi-vulnerable persons are actually taken care of. We ensured that whether it's relating to dealing with reporting, investigating, or indeed healthcare services, these are included and not excluded due to their status. So we have incorporated such provisions. Thank you, Mr. Bandek.
Thank you very much for that. Could we try with Mr. Saha again? Mr. Amitrajit Saha?
Yes, thank you.
Thank you very much. Please go ahead.
Can you hear me now?
Yes, we can hear you.
Okay. Good morning, good afternoon, Secretary General and all the excellencies present and colleagues and friends, especially also referring to Mrs. Jhala for her excellent presentation. All protocols observed. I am from UNDP, and I just wanted to, at the beginning, thank the SADC Parliamentary Forum for putting together such a comprehensive draft model law. As we all know, that model laws are models for countries to help address their legislations, and as was mentioned during the keynote speech today in the morning, the previous model laws have actually helped national legislators in sub-Saharan Africa to help with changing their laws and policies, particularly in the context of age of marriage. So this has been a great effort. I just wanted to commend and the SADC Parliamentary Forum, all the partners and enablers for this exercise. I just also wanted to, I have some general comments. I also am very much appreciative from the point of view of UNDP's work. One of the areas that we work in is provide support to national governments through strengthening the rights and privileges and entitlements of people who are not, who are not gender, who are beyond the gender binary context, who are primarily from the LGBTI communities and from trans communities, and that the language has very, very clearly articulated the challenges of, gender is not just merely a binary man woman in this particular document, is also to be commended upon and thanked upon. It is, I also understand from Mrs. Jhala's comments that it was a great challenge to put that language in, but that the language is there and that the draft model law contains the language is in itself a great victory for SADC and for the partners who have helped in putting this together. I think that the question that finally comes, of course, is the point of implementation, and the point that Mrs. Jhala has made and the draft makes of having a holistic approach, a whole of government approach, is, I think, very, very critical, and therefore, particularly addressing social norms, addressing traditional value systems, challenging them to an extent so that changes are made in the national legislations is very critical. We must not forget that women and girls are women and girls in all their diversity, and the diversity language needs to be maintained and kept as far as possible, and domesticated at the national levels in the region, which I dare say is going to be a tough task, but it is good that it is the model law articulates it very clearly. I also wanted to find out really when the consultations were happening, where the consultations happened with LGBTI communities, communities of young women, young trans women, or young lesbian women as well, when the consultations for this model law is happening, because this language has been so nicely put. So I was just wondering whether we could understand, if not, what else went into their engagement. And finally, I just wanted to, as always, UNDP in the Africa region and elsewhere, in Sub-Saharan Africa region, we are firmly pledging our support to follow up any follow-up support that we may be able to provide the Parliamentary Forum in rolling out the draft model law, and in also helping the national level, national legislators to domesticate it. There is a tough journey ahead, I guess, with not only sensitizing our parliamentarians, but also our duty bearers at the national levels, including the security staff, the police, on the overall context of gender, and then overall context of some of the major challenges that come, major barriers in forms of tradition, in forms of traditional practices, religious practices, which also needs to be addressed and encountered in some other way. But nevertheless, it has been a very exciting journey, and I wanted to thank everyone. And while we look at it more closely, definitely there will be situations where we will be able to raise certain other flag certain issues. But overall, congratulations and pledging our support going forward. Thank
you. Thank you very much, Mrs. Jala. Would you like to comment on that and to respond?
Thank you very much. Just to thank Mr. Salah for the wonderful comments and praises to the GBV model law. We are trying our best to ensure that we even enhance it better with all the comments coming in or to come in from our various stakeholders. On the consultations with the LGBTQ, maybe SG can enlighten us more on that.
Yes, sir. SG? SG, are you still in? Okay.
Yes, I'm here. I'm struggling with unmute and the rest of the stuff. Apologies for that. And I don't know, there's a strike outside, so we're so distracted. People have descended on the premises of Parliament and shouting. So if you hear that noise, it's yeah. So please repeat the last part of the question that you wanted me to address. The process going forward.
They're seeking a comment on what consultations have been undertaken with the LGBTIQ community regarding the model law, and if there haven't been any, what has gone into this model law, because the language seems to be correct, so to speak.
Okay. Thank you very much, colleagues, for that. As you know, let me just say that we come a long way as a SADC Parliamentary Forum with resolutions that are sensitive to key populations. We've been implementing for the past, since 2007, we've been implementing a project funded by Sweden, which looks at issues of sexual reproductive health and rights and governance. And therefore, our resolutions empower us to be able to use evidence to infuse into most of the instruments that are done at the regional level, without usurping the powers of sovereign countries that are members to the SADC PF. And we continue to use diplomacy and persuasion to be able to allow countries to adapt at the right pace as and when they are ready to do so. We've also done, minimum standards for key populations with UNDP, UNFPA, and this has also been part of how we build a culture of respect for human rights at the SADC Parliamentary Forum. That is why you find that we are inclusive in our approaches, and the principle of no one should be left behind dictates at the end of the day. We have not had consultations with key populations deliberately per se. We have sent out an open invitation to all the partners of the technical working group. ARASA was the only organization that actually assisted us to bring in the diversity of civil society and partners that are out there. And we did have input on some of these issues, some of which is still under consideration. There was a request to actually go a little bit broader in infusing in the articles the realization of making sure that we don't leave key populations behind, especially the LGBTQ. This is something that the drafter will be looking at, and where possible, that will be done, or it will be left where it is broadened enough, or improve on the definition where need be, as it has been proposed. But by and large, we believe that what we have received, it has been commendations and appreciating that it is not possible to deal with everything in such a model legislation, that it should be left to countries ultimately to assist in that regard. So should you still, well, we're closing our consultations in October. However, should you feel you work with communities that require us to share the model law with, we are willing to do so. And if we can only do it latest, we're closing out the first week of November. The legal drafter will be busy now sitting to be able to integrate comments. However, we have Mrs. Musonda, who has been mentored by the legal drafter to be able to represent her where it is critical. I would leave it at that and hope that I've been able to respond to the query positively. And I must apologize to UNDP. We should have deliberately pursued you so that you can bring together the groups that we consulted when we did the minimum standards for key populations. But we are still open to further discussion in that regard. Thank you. It is very noisy. I hope I'm distracted.
Thank you, SG. We can hear you, I think, quite well. We'll go to Mr. Nicholas Etiang, and then we'll have Mr. Davis Chitundu before we go back to Mr. Amir Batenga. Earlier we had Chisomo Chaweza, but I think they've taken down their hand. So let's have Mr. Etiang, then Mr. Chitundu, and then Mr. Batenga. If we can be a bit quick, I'm just trying to keep a tab on the time. Thank you.
Thank you very much, Madam Moderator, and thank you, Eva, for the very insightful presentation on this model law, and thank you, SADC PF, for taking this bold step. I've had a scan through the law. I must commend the draftsperson. This was a job well done. There's a lot of positives given the context of Africa, especially the Southern Africa region. I come from African Population and Health Research Center, APHRC, based in Nairobi. And we do a bit of work on the southern part of Africa and also East Africa and West Africa. I think you are leading the pack by developing this kind of law towards ending violence against men, women, and girls and children. I have three or so areas that I just want to point out. Number one is there is no mention on reparation as a mechanism for justice. At the preamble, there is reference to the Maputo Protocol, which has a provision for reparation for victims of SGBV. Specifically, Maputo Protocol references that to women. In the preamble, you attempt to do that, but then in the provisions of the law itself, that is completely absent unless I missed it somewhere. Bearing in mind that really victims of such offenses go through a lot of agony. Sometimes they have to expend to seek medical services. I know the justice system focuses on punishing the offender, but then leaves out restituting the victim. So if you may consider that, just make a comment unless I missed out something. And then again, in your presentation, you talked about this law focusing on women and children, and you were attempting to justify that they are the majority of the victims. If you look at the provisions, they're actually speaking to that. They're very much leaning towards women and children. We are talking about leaving no one behind overall. So we really need to include the men. For example, just a declaration of right. If you look at, say, Article 19, which speaks to the right to health, I mean, it goes straight to just declaring rights of right of health for women and children. I thought declaration of rights should include everyone, and then specific services can then be tailored for the differences or the variations we have in society. And then thirdly, we also need to be cognizant of the fact that there is a lot of violence that is being driven by technology. The law does not address that element. Technology facilitated gender-based violence. Probably you'll need to have a look at it also. And then finally, probably we are coming into the process late. It will be our pleasure to receive the findings of the study that you undertook to assess the status of the legal environment or the legal landscape among member states, to just enable us get that background. I'm speaking on behalf of the African Population and Health Research Team. We may benefit from that as we get into the way forward and engaging at national level. We need to have a good understanding of what is obtaining at national level. Otherwise, I wish to thank you very much. Yeah, this is a good law. Thank you very much.
Thank you very much. Before we get to Mrs. Jala, maybe we hear from Such Tundu quickly.
Okay, thank you very much for this very comprehensive presentation. My second question is actually, first question is overtaken by events. What I just wanted to find out was, when you look at the definitions of GBV, the UN and SADC adds especially the aspect of the economic deprivation. And when we look at this, it appears as if there is a lot of focus on the criminal approach where you punish the offender, but there are also civil implications whose objective is to compensate the victim, which is very similar to what the colleague talked about in terms of how do you award the victim, I mean, apart from just putting them maybe behind bars. So the combination of the civil and criminal elements of the definition. The other one, I just wanted to say, it's good that you did raise the issue of religion and this impact on social norms, as it were. As you know, one of the definitions of law is sociological in nature. It reflects the way of life for the people, be it spiritual or cultural, and just how these, contradict each other, those which are repugnant to the rules of natural justice and how they can come in, seems to be quite a very big and serious challenge. Thank you very much for the presentation. Bye.
Thank you. Mrs. Jala, would you like to respond?
Yes. Yeah, I hope I've got everyone's comments in. Thank you very much, all of you, for just giving us some commendation on the model law. The issue of reparation, we've dealt with it extensively in the model law, very extensively. So we've provided adequate remedies, including restitution. If you go to Section 32, financial assistance from the government, the forms of compensation that a victim can obtain from both the perpetrator and the state. So yes, we've thought of that aspect and we feel it's a very important aspect of GBV, and we extensively dealt with the issues. So maybe some, as I pointed out, page 92 can give you some indications on how to deal with it. And these extend to orders, what type of orders the court can actually issue in relation to privileges of the victim and victim's children, by the way. Then on the issue of technology, yes, we need to look a little more closer to this issue and see how effectively we can ensure that it's included. But we've tried in a small way to deal with it when coming to the tracking issues, the monitoring and evaluation, the research and methodologies that need to be used in order to effectively fight GBV. But we can still relook at it and see how we can enhance the provisions. And then another issue on human rights, the way we've dealt with human rights. Yes, but if you look at the general human rights, it is the general rights of everyone, men, boys, and girls. But we've provided and included therein special provisions relating to women and girls and the adolescents because of the very nature of GBV. The very nature of GBV, the vulnerability of these groups. We've also dealt very much in the law with other vulnerable groups and provided for them in the policy directions of every government, every member state. What policy direction should they take in relation to these groups? With a firm policy, then legislation is much easier. We've also ensured that there's adequate cross-referencing to appropriate legislation dealing with these vulnerable groups, whether it's traffic, in terms of trafficking, refugee, asylum seekers, and so forth. So it may look on the face of it that it deals more with women, but reading it closer, you'll find that it's of general application and general focus. So I hope I've answered that. The issue of the sociology of the law, I entirely agree. I entirely agree with that. Law has a lot of aspects in relation to this. So we have ensured that the definitions, we've looked at both definitions and we have simplified them for understanding, but we have done something further. We have created without doubt clauses for avoidance of doubt. The word victim, the word GBV shall include the following. And if you look at what we've stated in those clauses, we've ensured that we have tackled every component and aspect of GBV possible. And if we have left out anything, then I would love to be guided on it. For example, one of our participants, I think she comes from Angola or something, I'm not sure, actually pointed out that we may need to revise certain definition to bring them up to standard with some new international definitions that have come up. And we are going to do that. We are going to do that. Another issue, no, I think those are the main issues. Thank you very much.
Thank you, Mrs. Jala. I see Secretary General. Would you like to intervene at this point, SG?
Thank you very much, Madam. Just to indicate that following the comment from APHRC, I would like to welcome the proposal that they've put forward, because we work very closely with them to help us just look at this issue of the GBV model law as they have proposed and see how they can add value for us to providing evidence for policy-making process and knowledge translation and evidence uptake. I believe the issue of GBV is one such that would benefit from such an exercise, and would like to encourage you to assist us also in unearthing the sociological linkages to law and GBV in this respect. Thank you very much, Madam Chair.
Thank you. I see Mr. Chitundu again. I don't know if this is the old hand or it's a new one. Mr. Davis Chitundu.
Very old hand.
Okay. Any further contributions? Any further contributions, questions, additions, subtractions maybe? I see none. I'm looking through. I don't want to miss anybody. Please just indicate if I've missed you. I see none and I hear none. So maybe at this point we could go into close. Also looking at the time, we're almost heading towards lunchtime. But before we close, we'll request. We're going to have a closing remarks from Dr. Bennett Nyana Bangi, Regional Director of UNFPA East and Southern Africa Regional Office. Unfortunately, we've been advised that Dr. Nyana Bangi was not able to attend the meeting, and so he has favored us with a recorded message. So I will request our ICT technical team to please play the recording for us as the closing message from Dr. Nyanda Bangi.
Honorable members of the SADC Parliamentary Forum, Ms. Boima Sekoma, Secretary General of the SADC Parliamentary Forum, Your Excellencies, members of the Diplomatic Corps, representatives of international organizations and United Nations agencies, distinguished guests, colleagues, all protocols observed. It is an honor and a pleasure to participate in this final stage of the consultative session on the SADC model on gender-based violence with the United Nations agencies and donor partners. Let me start by congratulating the SADC Parliamentary Forum and the Regional Women Parliamentarians Caucus for this crucial initiative. The motion to develop the model on gender-based violence was unanimously adopted at the 44th Plenary Assembly session held in Maputo, Mozambique in 2018, and was the beginning of a critical process to address the current shortfalls in national GBV registration and prolonged implementation gaps. Distinguished guests, since 2019, UNFPA has supported this process, starting with the first consultative meeting with the SADC Regional Women's Caucus held in Johannesburg in September 2019. Over the past 2 years, UNFPA has been privileged to work with the SADC Parliamentarian Forum to galvanize a broad range of stakeholders from regional economic commissions, civil society organizations, UN agencies, universities, and research institutions towards the development of the SADC model on GBV. We are delighted that we are now concluding the consultative process before the much anticipated adoption of the comprehensive model law. As you know, achieving zero gender-based violence and harmful practice
is a key priority for UNFPA globally and in the East and Southern region. Gender-based violence is a persistent threat to peace, security, and socio-economic development in the region, where a third of women have experienced physical and or sexual intimate partner violence in their lifetime. Simultaneous humanitarian crises resulting from both conflict and natural disasters in the SADC region have increased the risk of physical and sexual violence for women and girls. The role of parliaments in legislating and examining government's policies and budgets during crisis and recovery is key to curtailing, deepening gender inequality and escalating violence. Data shows that in 2021, 19 African Union member states still do not have specific national legislation on domestic violence. Where laws exist, these are often limited in scope and coverage or are poorly enforced. The current implementation gap is failing women and girls. Lawmakers in the SADC region must protect women's fundamental rights to make decisions over their bodies and over their futures. This includes the reform and enforcement of laws and policies that criminalize all forms of violence and harmful practices and crucially support the provision and access to sexual and reproductive services and reproductive rights. Laws must also seek to empower women and girls, particularly those most likely to be left behind, including adolescent girls, women and girls in rural areas, and those with disability. We must ensure that marginalized and disadvantaged women and girls are enabled to make decisions and govern their bodies by providing them with a full range of sexual and reproductive health services and information, investing in comprehensive sexuality education, and working with men and boys as allies and champions for gender equality to change norms and behaviors. Without these legislative actions, the promise of the ICPD program of action, the Sustainable Development Goal, and the African Union aspirations of the Africa we want will remain out of reach. Excellencies, distinguished guests, colleagues, we see the SADC model on GBV as a critical tool to ending all forms of gender-based violence and harmful practices by 2030. As models are based on the best norms and practices contained in generally accepted international instruments, the SADC model on GBV is a vital instrument, along with the SADC model on child marriage and HIV, achieve SDG 5 on gender equality and its targets. As we have seen with the SADC model on child marriage, model laws also act as catalysts for the domestication of treaties and covenants, as they contain similar norms and are further adopted to the Southern African context. The SADC model will also assist SADC member states to harmonize their GBV response, providing a cohesive regional approach to response and prevention mechanisms. Honorable members of parliament, distinguished guests, UNFPA remains committed to support and accompany adoption and post-adoption process. The SADC model will only fulfill its potential if it is understood and adequately used by those whose duty is to provide an enabling legal and policy framework. Those who develop and implement programs and interventions to prevent and address gender-based violence. UNFPA looks forward to strengthening our important partnership with the SADC Parliamentary Forum as we continue to work together to support the domestication of the GBV model in the SADC countries. Congratulations once again for coming this far. In this decade of action to deliver the SDGs, it is such actions that are building toward the full realization of the rights and choices of women and girls every day and in every way. I thank you for your attention.
Dear colleagues, thank you very much for your attendance. We appreciate your attendance and sparing time for us to share with you as part of the work that is ongoing on the GBV model law. Hope to hear from you. You are welcome to make submissions as already indicated, and we look forward to your support going further. With these, I think, please, let's kindly terminate the session and have a fruitful afternoon.